I got a great question that was asked of me on the internet that made me laugh. It was Jason, what are some easy instructions for how to make a will in Florida? So, and that made me laugh, but okay, let's get into it. Here are some easy instructions, step by step, how to make a will in Florida, okay? So first of all, what we're gonna do is we'll go over the requirements. First of all, the person making the will has to be of sound mind. They have to be competent. So that means they can't have advanced dementia. They have to be able to understand what's going on around them. They need to be able to be making their will intelligently. And they have to be an adult. They have to be over the age of 18. So step number one, be competent. Step number two is understand that it has to be in writing. You can't give verbal instructions. There's no dying declarations for what the will is going to be. It has to be in writing. Step number three is it has to be signed. That's not necessarily a formal signature. Some people sign by marking an X. Some people sign with a symbol, right? There's people who don't know how to sign or because of a physical disability cannot sign. And a notary can do it, if they just don't have the capacity, or they can just make any type of mark whatsoever. But of course, if it's possible, your normal, typical signature is what's going to be preferred. It must be signed in the presence of two witnesses. They can be any two witnesses, even someone who is inheriting from the will themselves. We don't advise that because that can create some issues if someone else wants to question the will or whether or not the will was signed with undue influence, but it is technically allowed. And then, yeah, that's really it. Competent, in writing, signature in front of two witnesses, and those are the easy bake instructions for how to make a will. And then, I think that what that naturally lends itself to is, should I hire a lawyer? Listen, there are free forms on the internet. Some of them are fine, and some of them are going to get you into a lot of trouble. So it's a little bit of a buyer beware. Of course, my advice is going to be, if you want a will, you should go to an experienced estate planning or elder law attorney in the state of Florida who could help make sure that the will is filled out properly, to make sure that it's beyond reproach, to make sure that no one's going to be able to challenge it, and things like that. One of the conversations that I will get into with my clients who come to me with a will is, are you sure that's all you want? Because a will is really a one-way ticket to probate court. A will does nothing for you or your heirs or your family until after you passed away and it's presented to a judge. Some people think that a will avoids probate. A will 100% is inviting a probate. If you want to avoid probate, you're typically talking about a revocable trust or a revocable living trust or a living trust. Those are different terms that mean the exact same thing. A trust is a way to get your assets into a trust with the help of an attorney, and the assets that are in the trust will avoid having to go through the court process after you pass away. Or I should say it's more likely that you will not have to go to court, because you can have people anyone can take anyone to court for any reason, but you don't have to go to court if you have a proper revocable living trust that's not challenged. So again, those are your easy instructions for how to create a will. I hope that you do hire an attorney, because you're kind of being pennywise and pound foolish, or however that saying goes. If you are interested in estate planning, Medicaid planning, long-term care asset protection planning, and if you have a will, or if your loved one had a will and only a will and you have to go through probate, we have a wonderful probate team as well. So if you need help with any of those services anywhere in Florida, please schedule a consultation today. Thank you.